Hey, everybody, it's Eddie from Tokyo. This is your cryptocurrency update from Japan, and I had a very long conversation today with attorney Alexandra Damsker. I've brought it down to a concise mashup of most of the points. She was formerly with the U.S. Securities and Exchange Commission and also with the international firm Mayer Brown. And Alex, as she is called, has been in the blockchain space since 2016. We spoke at great length about the SEC versus Ripple case and the summary judgment. She currently serves as legal and operational and strategic advisor to a number of companies, including INX. INX was founded 5 years ago. It's a compliant public company. They claim to have the first security token registered with the SEC, and they do that trading on their alternative trading systems platform. They have a money transmitter license in 46 states and a broker-dealer license for these security token offerings and crypto. You'll hear that she disagrees with an orange can't be a security on its own. I think it's all boiling down to individual interpretations. And at the 18-minute mark, it's also interesting to hear her talk about how she would have argued the case. You know, this securities law is very complex, and we're finding that it has its unpredictability. Do enjoy.
Summary judgment basically means before you go to trial, you say, look, we have all the documents, we have the we have the complaint and we have the response, right? So we have all of basically the case laid out for both sides. And each side is saying to the judge, look, if you look at my side entirely and you take everything the other side says as true, there's no reasonable jury that would vote or rule for that side. So you must rule for me. And both sides said the same thing, right? For each of these issues, taking the case that I've laid out with all of the elements and accepting everything they've said is true, they've not rebutted the presumption sufficiently. They've not or presented their own case, their own prima facie case or affirmative defense. So you must rule for me because no reasonable jury would rule for that side. And so what the judge did is granted each one in part and denied in part. The second thing, so it's not over. The second thing it means is XRP is a security. Remember, that was part of what it was granted, was that it was a security in these institutional offerings. We're going to put a pin in that because we're actually going to go through this response and you'll be able to see what these things mean. But just remember, that's one of the things that was ruled. When you asked about whether or not it's going to be overturned, nothing's final until it gets to its final appellate phase, which is the Supreme Court. There are 3 phases. There's the trial court, and then the appellate court here would be a circuit court. And then after that, it's the Supreme Court, and the Supreme Court has to agree to see it. There's the losing side on any matter has the right to appeal as long as there is a proper matter of law at issue. They don't get to argue the facts on appeal. They only get to argue the law if there's a mistake of law. And then if there's interest in money and appealing, depending on what the decision is, because it could come out in your favor, in which case you don't care that there are these mistakes of law. If it doesn't come out in your favor, you look at the mistakes of law that you think happened, you confirm that those mistakes happened, and then you put them in your appellate brief and you file an appeal. If they want to appeal the summary judgment, these don't, to my knowledge, right, these are not final rulings that they can actually appeal immediately. They have to wait until there's a final adjudication, and then they can appeal these. They cannot appeal them right now. We have no idea when this final ruling is coming out. We know that there's probably going to be a trial coming up unless they decide to settle the remaining issues. But we're very far from the end of this. This is not the same thing as something coming from the Supreme Court.
So the secondary market sales, though, is what the XRP holders are so, focused on. That is not up for any change, right?
Oh no, this all of it is. That's part of the summary judgment, right? And that is actually very likely, that's one of the areas that's most likely to be overturned, to be honest. What the judge is saying is that the people who purchased those tokens did not have any contact with they didn't know that Ripple was selling them as opposed to someone else. So how could they know that it was a security? But that's not the test. That's the problem. That's not the test. That's like saying I bought shares. So Apple has a shelf registration, right? So Apple can sell a bunch of shares directly and also some selling shareholder shares, right? So they're mixed together on the stock exchange. Now I buy a share. I don't know if my share is from Apple or if it's from a selling shareholder or some other third party, right?
Right.
I did not talk to Apple. I didn't talk to anybody. All I can do is look at the information that's available, right? And I make my decision to purchase these things. That doesn't make it less of a security. The fact that I didn't speak to the founding team does not mean that it's not a security. So this is a long-standing thing. This is an issue of law. And this is something that, unfortunately, is very likely to be overturned simply because that's absolutely not how it works, right? There's another presumption on here that I find, frankly, incredibly insulting, which is basically like that the retail investors who purchased could not possibly have known what all of the information released by Garlinghouse, Larson, Ripple. They couldn't possibly have known what any of that meant. So it's impossible for them to have used any of that information and as a security, which is and invested as a security, which is what the institutional investors relied on. They relied on these brochures and conversations and statements. Now, what an insult to say that the retail investors are too stupid to understand what these documents are. That is actually what it says. Go ahead.
I think there are a lot of investors, though, that were looking at the market cap, just looking at tokens and thinking, well, it's got the third largest market cap, or it has whatever, at what time they looked at it, maybe it had the sixth largest market cap. And so not doing the research, but just going based on market cap. And I do think a lot of people made that decision. Well, it's one of the top 6. So I think I'm going to add it to a portfolio and make my portfolio more diverse. And I think a lot of people do make a decision without.
That is very likely true, but here's the thing. There's no obligation that anyone read any prospectus or information.
No, there's not.
Merely that it's available. So here's the thing. They're saying this information is publicly available and all this stuff is available on social media and they appeared on news shows, etc. And they're either saying that somehow retail investors are in a bubble and not available, like all this stuff that was clearly available to the public that the institutional investors relied on. Somehow retail investors were either immune to all of this public information or are too dumb to interpret this stuff. And I think that that's false. But there are better arguments that they should have made that I think would have made a big change.
Yeah, I'm curious to hear what you think those are. But also, can I just go back? Don't you need an investment contract to satisfy one of the prongs of Howey? And there is no investment contract with the
there's no requirement for a contract. That was one of their ideas, is this like post-sale obligation and a contract. There's no need for, first of all, an actual contract. And remember that investment contract is one part of one list, and there are several lists of things that may be securities, right? So we focus a lot on this because it was just in one of the no action letters and we don't have a lot of like litigation to go through, but securities has an extreme, like a lot of litigation in its history, and it's not all Howey. right? It's not all investment contracts. There's a ton of other ways that things can be securities. For example, DeFi has a ton of securities issues, none of them related to Howie, right? There's a ton of securities problems that just because there's an issue related to this particular thing doesn't mean it's exclusively Howie. So, but for this particular thing, the investment contract issue is not the issue. These people paid money for something in the anticipation, like it was speculative, in the anticipation that it would increase in value, that they could sell it later for a profit, right? And they weren't doing anything to drive Ripple, right? They're not part of the Ripple engine. They're not the people who are writing the code or pushing the code through. That is basically Howie. That is the argument that that's a security. And that's the whole thing, is that they bought it because it was going to increase, and they bought it relying on the same statements and documents, et cetera, that the institutional investors heard. Everybody heard the same thing.
Okay, let me just give you 2 use cases, and then you tell me if it still falls within that realm. If you're going to use the XRP ledger, for example, to create a decentralized app or even a centralized app to move value across the ledger, so you're using it to move Bitcoin, whatever, and the XRP is used to secure. It's the native digital asset that secures the ledger. So it really needs to have that asset there to keep the ledger secure, from spammers and what have you. It's essential that it has a native digital asset. So you've got a person who doesn't care anything about the XRP as an investment tool. They're only relying on XRP to keep that network secure, and then they've used it in their application to move Bitcoin from Canada.
See, that's better. That's not what was in here. Sorry, but that's better. That's better. See, that's using it. But that's not a speculative investment.
But that was in one of the amici's that was presented by John Deaton as a use case.
But that is not, so this court, okay, just a quick second on amicus briefs.
Yeah.
Okay. An amicus brief is a friend of the court, right? Where basically you could have on either side, you could have an attorney or a foundation or something who basically operates as an additional lawyer for like buffeting up the case of one side or the other. Now, the Supreme Court puts great reliance on these, but the lower down you go in the courts, the less they rely on these things, right? You can have courts that even bring the amici into the case, right? So this is amicus, it's called amicus curiae, right? And that is, so if anybody wants to look that up, and there were some very interesting ones. There is no record that I see officially of those being considered as for this particular action. That's not what's in the decision, right? We have to look only at what's in the decision, and we're not looking at, I can't tell what's in, what's in her head, what's in the judge's head. I can't tell, anything else, like other than what she wrote here. I'm not her clerk. I can't tell what she considered, but from what's in here, I don't have any other information. And what's in here, she did not consider the possibility that people buying from the exchanges were using the token as a token, not as a speculative investment. That would have been a much better argument. That would have been a much better argument. That would have been an argument that would be, in my opinion, right, much more insulated from appeal. So for this one, what I would see happening here is that this particular, this decision, this little part is very easy to appeal. But hopefully what happens is XRP in combination with the amicus brief comes and brings in this argument and says, we also have, this consideration has happened. Now, the only issue is, does it bring in new facts? So what we have to do is bring in this information only as a matter of law, not bringing in new facts, because you can't bring in new facts in the appeal. But I have faith that the people who are appealing are very good at appeals and appellate work, and understand exactly how to make that, how to word it so that the information can be conveyed and won't be thrown out because it's inappropriate.
The other perfect case is when many of us in the XRP community that were being, we were maintaining blogs, and those blogs, when people read them, they would stream micropayments of XRP into our exchange account. And so we weren't purchasing them. It was being used basically as a currency. So, I mean, I think you can come up with many examples where XRP
that one not as good. Sorry,
not as good, but I think you can come up.
But the other one very good.
Yeah, but I think there's many examples of where XRP was being used as a tip token. Where you would tip people, and then, I mean, it just wasn't always purchased for the hope that it was going to go up in price and you would be able to exit out in a position of profit. I just don't think that's always been the case. And I guess also too, I just am confused because I thought it was all about how the token was sold makes it an investment contract, but the actual token itself can't be like in Howie, the oranges aren't tokens.
That's a lot of what I hear from people who are huge fans of that's a very
but
that's a very pro XRP argument but we've been passed around.
But we've been hearing you could turn anything into a security based on the way it's sold, right? But the actual item itself it can't stand alone as being a security, right? It's the
there are things that by their nature are securities. There are things that by their nature plus the way they're sold are securities. There are things that regardless of how they're sold are never securities. There are things that regardless of how they're sold, but or that by their nature but regardless of how they're sold are securities, right? So there's an array of things. Securities law is actually extremely complex. It's a very technical area, and that's why there are securities lawyers. If it were literally just this one very easy thing, people have been desperately trying to boil down securities law into this one like three-prong rule, and unfortunately, that's just not it, right? Look, if we have bright line tests, we may have people who are accidentally caught that shouldn't be caught. And we are more interested in fairness than clarity. So you kind of have to pick your poison. And no matter what you do, it's going to be wrong, right? Somebody's going to get screwed. But the nature of American law tends to be more towards fairness than clarity. But that means that it's confusing. Right? So in order to come up with rulings that fit particular circumstances, every single case is decided differently, right? Like it should be like cases decided alike, but you've got to try each individual case, right? So in order to try each individual case on its facts and hopefully come out with a fair ruling for each individual case on its facts, you have like unpredictability. That is in my opinion, the worst part of our system. And that's one of the things why, we talk about issues of legislating from the bench and things like that, because the one thing that is most important, especially in business, is predictability. It's like, it doesn't matter what the rule is, as long as you know how it operates so that you can figure out how to work with it or work around it or whatever it is. It's really hard to have an unpredictable rule. But for a lot of reasons, this particular rule is actually fairly predictable. This section of the rule that token lovers, I'm a token lover, that token holders, thank you, token holders love to go after. Well, I don't think it's a security. Is it a security? This to me is a non-starter because it's entirely in the playground of the SEC. Who determines if something's a security? The SEC. They are the arbiter of whether or not something is a security. Here is the thing I would have done differently, and I'm going to mention it because I have no doubt this will go to appeal, and I hope that this is brought up. The better argument, in my opinion, would have been, yeah, okay, we are a security or we're not a security, doesn't really matter. We wanted to comply, but we couldn't. How do we comply? It doesn't matter if we're a security or if we're not a security. We can't comply.
Yeah.
So for example, now we have ATS systems for institutional investors who have securities, right? But then we didn't. We didn't have anything. What could they do? They could trade on the systems that we had. Oh, could they register and go onto systems that took securities? No, they couldn't, because none of them take tokens, right? We now have INX that takes tokens that are registered. But before INX came this year, what did we have? We had nothing. There was no way to do that. Oh, you would like a special purpose broker? Show me one. So it's, this is the stronger argument. You want compliance. We are happy to do so, but we cannot. That is actually the core of the problem. It's not, is it a security or not? It's what do we do with this stuff? Because the rules, it doesn't matter if it's a security. We don't have a system that we can comply even when we want to. So we're doing the best we can and telling you what we're doing, but we can't do better than this because it doesn't exist. You haven't made a path for us.
Can you use this argument in the appeal, or is it too late?
So again, not an appellate attorney. I would find a very good appellate attorney, and I would hope that you could. I think that this is a solid argument. I don't know if it can be raised on appeal because it's not raised in the case. However, the case isn't over. So hopefully someone will come up with this and say, can you please raise this as an issue, saying that it's irrelevant if it's a security, right? The problem is, and this is a problem for more than just crypto. This is something that we have to look at a broader approach here, because fundamentally, all of the securities rules are predicated on this idea that broker dealers are like the hub, right? And all the rules are like spokes that come off of it. But broker dealers haven't been the center of securities transactions since the end of Glass-Steagall around 96. That fell, right? So most of these rules are almost impossible to, we have to add in pieces in order to make these rules work. We have to add in additional people and additional steps to make these rules work. Like, you have to add in elements that introduce fraud. That doesn't make sense to me, right? So we have a system that can be automated. And at this point, with an automated system, you have reduced fraud potential. So we would think, okay, reduced fraud potential, this is better. But for us to comply with the system that the SEC has, we have to introduce a broker dealer. So we have to introduce a human. Go ahead.
So is that why you think Prometheum received that special broker dealer license?
So somebody needed to get it. Why was it Prometheum? I can't tell you. I don't know anything about the details of why they specifically received it.
I'm not saying just them in particular, but do you think that was the reason that the SEC chose to have that broker dealer be put into place to show that they are indeed providing some?
Yes, I think it became clear to them that there was no path for people. So once INX came out, it was clear that they were still missing this one. They weren't a special purpose broker.
Right.
They still needed one. What are we going to do? Right. So, so that is where I think that, there's still a lot of rules that don't make sense. Like, how am I supposed to follow, counterparty reporting obligations when, my counterparty is an alphanumeric code with a cat NFT in it? Like, I'm not sure how that's supposed to happen. Right. So there are a lot of different obligations that still occur that don't make sense, but, they don't make sense, not just for us. There are obligations that really don't make sense for a lot of people. Right. I mean, personally, I will jump on the bandwagon with anybody who wants to take down the accredited investor rules. Yeah. That is the dumbest rule I've ever seen. They should not exist. Right. Add a gate, not a wall, right? Tell us how to move from unaccredited to accredited. Don't just say, oh, well, you can't get money because you're poor. Well, but wait a minute. Bad thing about being poor is I don't want to stay that way. I'd like to be able to get into some of those deals, which are the most assured way to gain generational wealth. So how could I do that, right? So anyway, I have a long diatribe on how these things need to be fixed, and I don't want to bore anybody with it. But
yeah, you're not boring me. I was part of putting up a free educational course that prepares you to take the Series 65, which is
good.
Yeah, and I worked with an investor who has the proper licensing, and the course is a self-study, and it's there now, and it's through the Genfinity website, and we wanted to give people the tools to take that first step to get to the accredited investor, status. But yeah, you're preaching to the choir when you talk that, because I feel the exact same way you do.